Divorce Cafe, the podcast where we demystify, detangle, and hopefully detox the legal processes that follow a separation. We are lawyers ourselves, and like everyone else, we are always saying there's got to be a better way. Well, today we are wondering whether we might have found it. Collaborative law abandons the hallmarks of a traditional legal dispute: combative lawyers' letters, a lack of human interaction, and at the end of the day, court. The name Selina-Jane Trigg is synonymous with the concept of collaborative law in New Zealand. She has been a lawyer and a mediator for over 20 years. Maybe well over now. I don't know if that bio is out of date. Not that you can tell by looking at you. Previously the chair of Collaborative Resolution New Zealand, which trains collaborative professionals in New Zealand. Now the first New Zealander to be on the board of directors of the International Academy of Collaborative Professionals, the IACP. Her focus for some years has been on training professionals to be collaborative lawyers, and has recently banded together with other lawyers to form Lighthouse Legal, which centres its approach on collaborative law. We want to know everything there is to know about collaborative law, so Selina-Jane Trigg, welcome to Divorce Cafe.
Oh, thank you. It's wonderful to be here, and thank you for that very generous introduction. I'm not sure I can share everything that there is to know about collaborative law or collaborative process in one podcast, but let's start the conversation and see where we get to.
Sounds promising. So Shelley is going to nail the icebreaker.
The first thing we do is the icebreaker, although you've just talked, so it's fine, we don't really need it, but we will do it. So I do actually have a bucket of icebreaker questions. I'm not going to look at them.
I added a few goodies just today.
If you could eliminate one thing from your daily routine, what would it be and why?
I'm laughing because it's the school holiday, or the end of the school holidays at the moment when we're recording this, and I have to say I have loved not having the morning routine of getting a teenage son out the door and in the car and off to school on time.
We don't know what you're talking about. We don't know. What?
I think I'm preaching to the choir here.
Yeah.
Along with the millions of other parents that are also taking their child to school on the first day.
Yeah.
Yes.
What we lose.
We'll miss it when it comes to an end.
Will we?
Yeah.
Okay.
Cool.
So we are going to ask you some questions, and then you can give us your very expert answers. So the first question we have is what was your pathway to collaborative law? How did you get here? What did you do along the way?
Well, it started about 14 years ago, and I'm not going to step you through the whole thing because that would take some time, but I think there were two main things that drew me to the pathway. And the first was very pragmatic. I talked about my son, and I actually just needed to find a way to work that was conducive to also being participating in his upbringing in a meaningful way. And the second really is summed up by what you said in the introduction, Tina, is there's got to be a better way. And I think a number of the reasons I was drawn to collaborative process are very much the same reasons that clients are drawn to it. You know, I was looking and seeking out a process after probably 20-odd years of litigation, or maybe a little less than that, of a process that was keeping clients out of court, because I was never hearing clients come to my door and say, oh, bring on court, I'm looking forward to it. I was looking for a process that made sense in terms of the time it took for the clients, having regard to where they were at in terms of their own emotional and psychological readiness to come to an agreement. I was seeking out a process that enabled clients to really participate in the final decision making and as a result have a sense of ownership over that decision, because I really believe that if that happens, results will be more enduring, that you won't get people back on your doorstep a year later needing to go back to court. So those were some of the reasons that drew me to it. I really, most importantly, wanted to find a process that reduced or at least contained the relational conflict between people who are going through a separation. Because I could see how sending off affidavits and letters and cross-examining in court wasn't actually conducive to that. And in doing that, it wasn't conducive to what was happening for the children in those families. And I'm really concerned about what templates we give those children for when they encounter conflict in their adult lives. So I was thinking there's got to be a better way, looking at all of that, looking at it holistically, not just the law isn't just one part of the puzzle.
Yeah, how did you come across it?
I went to a mediation training first of all, as so many lawyers did. I went to a mediation training run by the New Zealand Law Society, and while I was there I met the amazing Dr. Gay Greenwood, who is a mediator and at the time was a lecturer at AUT University. And I am so grateful for her guidance and mentorship over the years.
We just interviewed her, so she's going to be, by the time this goes live, her episode will be up there. Oh, it's a cool coincidence.
Brilliant. And she encouraged me to go to a collaborative process training. So being quite in awe of Gay, I said, absolutely, show me the way. And I haven't looked back. It made perfect sense to me. It was very challenging, the training, but it led me to being involved with Collaborative Resolution New Zealand, and then led me to the International Academy, which I have to credit with the development and the skills and the learning that have meant I can now say I don't go to court anymore. I don't litigate. I focus on collaborative process and mediation.
Cool. So so that we all understand and so that we know, what is collaborative law? How does it work?
Yeah. So first of all, you've probably noticed I've referred to collaborative process or collaborative practice. That's how I prefer to refer to the process rather than as collaborative law. And I do that for two reasons. The first is it's not just the domain of lawyers, this work. It is an interdisciplinary model. And the second reason goes back to what I mentioned earlier. The law is only one part of the decision-making process that people go through when they're resolving the parenting, the financial, the property issues that arise on a separation. So law is part of the solution, but it isn't the complete answer. So that's why I tend to call it collaborative practice, collaborative process, sometimes collaborative divorce. But put really simply, it's a dispute resolution process in the same way that mediation, arbitration, and litigation are all processes that aim to bring an end to a dispute. This process is slightly different in that it is completely outside of the realm of the court. So it was created about in the early 1990s by a lawyer in America called Stu Webb, who was really looking for a truly out-of-court resolution process that engendered respect and cooperation and an interest-based approach to problem solving with the participants. So typically, in terms of how it operates, if a couple are separating, they'll engage specially trained professionals to take them through the process. And everyone, the parties and the professionals, will sign a participation agreement, which says a number of things. It says, importantly, they're not going to go to court. As I said, this is the only process where you say, while this process is afoot, neither of us are going to threaten court and we're not going there. Which is really important because it means it's not what we call litigation. It's not negotiation with a parallel litigation strategy happening alongside it or overlaying it. So typically both parties will have their collaborative lawyers guiding them and advocating and supporting them through the process. But as I said, it's interdisciplinary. So there are times we will bring on financial neutrals or mental health professionals to help work through the process. And there are just some jurisdictions now where the lawyers recognise the benefit of those professionals so much that they'll refuse to do this process without a full professional team. I think one of the key aspects that make the process different is that there are no lawyers' letters. No letters going back and forth that can potentially inflame things between the parties, no matter how well-intentioned we may be when we write them. And so that's a really important aspect of mitigating and containing that relational conflict between the parties. And everyone, including the lawyers, agree to be transparent, to be open, to act in ways that are really moderate, very respectful, and really conducive to constructive problem solving. So that really gives the parties an opportunity to observe and have modelled to them constructive resolution techniques. And so there's an opportunity there for them to actually deploy those in the future, for them to learn and adopt new ways of relating to one another in this new chapter that perhaps as co-parents they're having to navigate. Yeah.
So there's no letters, but I understand you schedule a series of meetings.
Yeah.
Is that how things work?
Yeah, everything's done together in a series of meetings. Those meetings may be the professional team, or they could be, but typically they're the whole group. They're the parties and the professional team coming together with very clear agenda. There's no blindsiding or surprising anyone with what's going to be discussed. Very clear homework and things to be done after the meetings. And we take minutes. It's very businesslike in that sense.
Okay. And is it correct to say that you generally will appoint one joint expert, like you'll have a joint accountant, maybe a joint valuer, those sorts of people? Is that how, are those some of the professionals that you bring in?
Typically with the financial professionals, they come in as a neutral for both parties. I know over in the US, they have different templates or models for how they work with the mental health professionals. They call them coaches there, whether they have one for both parties or each party has their own professional working in that space with them. Yeah.
Is there ever a lawyer for child?
We don't have a lawyer for child typically, but this is a really interesting space that both mediation and collaborative practice are exploring, and that is, how do we bring the voice of the child into the room? One way is to have perhaps a lawyer who's that the parties engage for that purpose. But what's happening that I'm watching with some real interest in Australia is using a child development specialist, so typically a psychologist or someone with that expertise, to meet with the child and to come into the process for the really, specific purpose of informing the team and the parties about the child's views, and also importantly what that child's particular needs are and stage of development mean is important for everyone to consider when making decisions about that child.
So really promoting that best interests kind of view. Okay.
Absolutely. And I in my collaborative cases, more often than not, we are looking for really cost-effective ways to work. So it may be we carve out the parenting aspects of of what needs to be resolved and send them to work with someone, a psychologist or someone who has specific skills in that area, or to FDR. As a cost-effective mediation that can run parallel to what we're doing. Yeah.
So the bulk of your matters, do they tend to be more relationship property and spousal maintenance rather than the Care of Children Act, custody, contact?
All of the cases will have aspects of that, both. But as I said, we tend to try and think, how can we work smartly here, which may mean carving off some of the substantive parenting decisions that need to be made. Right. Obviously, when parties first come to the collaborative process, they may have some interim and urgent things to resolve around, well, what are we going to tell the kids right now? What are we going to do in terms of their care arrangements until we can put some deeper thinking and thought into this? And so we would work with them on those issues.
Okay, cool.
Okay, next question. Does it work? And does the collaborative process work? Do we have any data or confirmation of that?
Yeah, well, yes, it does. There are tens of thousands of professionals around the world who wouldn't be doing this work, and some have been doing it for well over 20 years if it didn't work, if they didn't see the benefits for the clients and their families and their children. Speaking from my own experience, it does work, and even in the really hard cases, because something I think is important to convey is this isn't a soft option for anybody. This is actually really challenging. There's nowhere to hide in this process. Coming together and working the problem together is hard work. But I'm really struck, even in those hard cases, by how much we can actually reduce and mitigate conflict, and how we can find some really beautiful creative solutions that are tailor-made for each particular family. So from my perspective, it works really well on those two levels. as a lawyer, it just makes for a much better day in the office. You know, I came to this work pretty disillusioned and pretty burnt out, I must confess. And I see a number of people coming to the trainings that I participate in who express similar sentiments. They express a sentiment of being out of alignment in their work with perhaps their own values at play. So a number of my colleagues express that same sentiment, that this is a really great way to work. It's a very fulfilling way to work. But in terms of your question about data, I think we can never have too much data, and it's well due for an update.
Yeah.
But there is a number of significant research pieces out there around collaborative process, and I'm told there is some research about to be published out of Florida. But what they all show is some real commonality around the process being cost effective, it being responsive to the client's needs in terms of the time it takes, really an adaptable process. And we're seeing really high, I'm avoiding the word settlement rates, really high resolution rates, similar to mediation, and high client satisfaction rates are coming through as well. And we're getting lots of reporting in that data that there are the high rates of agreement also are married up with longer lasting resolutions, that we're not getting people back a year later needing to relitigate things. Yeah.
Okay. Is collaborative law for everyone?
No, it's not. Just as mediation isn't for everyone, and I would say litigation isn't for everyone. It is most definitely not for the person who thinks, oh, this will be a soft option. It is definitely not for the person who thinks they can use the process to get one over someone or one over, get one-upmanship in the process at all. Like any process, when you're working with families going through these high levels of stress, it needs to be a safe process. And so when we're meeting with clients, part of our training is to be screening and assessing what is going to be the safest, least intrusive process for this family. What's going to be a process that aligns with how the clients are saying they would like to navigate this time and this transition in their families' lives. So, I would just challenge my legal colleagues to also ask similar questions around the appropriateness of litigation. Is this suitable for my client? Is this going to be empowering for my client or not? Is it going to give them opportunities to change the conflict dynamic between them? Is it going to be cost effective? Is it going to be safe?
Yeah. So how I note that you can't get legal aid for collaborative practice.
Newsflash.
Okay. Well, I'm interested to hear. What I was going to ask was that it seems that the most of the users are, the more well-off Pākehā people. How can we expand? It seems like a process that could benefit, more people. How could we expand out the people who
Absolutely,
can be
and legal aid is one really critical area in which we can make the process far more accessible to many. I always say that when I win Lotto, I'm going to set up a special project that provides low or pro bono collaborative process for people, but I don't think anyone should hold their breath and wait for that. It's taken years and lots of work to try and get the government and of whatever time it is, and legal aid in particular on board, but just a couple of weeks ago, a case I'm involved in, we've managed to get through some really great work by Sarah Vile at Den & Bramwell, legal aid for her, for a client of hers. So that's, I'm hoping, going to signal a change in approach and make it more accessible. Yeah.
Oh, cool.
Okay, so what do lawyers have to learn or unlearn to make collaborative practice work?
Yeah. So like I said earlier, you do need to be especially trained in this process. And it's not a one and done thing either. It's not just come to the training and suddenly you finish the training and next Monday you're a collaborative lawyer and you've got, dealing with cases all the time. It takes quite a commitment to ongoing development, just like any skill. You need to keep learning, and also quite a commitment to changing up the way you practice as well in order to be able to attract collaborative work and to be utilising it. It's very easy to fall back into your usual comfort zone of how you practice. So I think a couple of the key learnings for lawyers are around moving from what we have and understandably have is a very positional, entitlements, right-based approach to problem solving, and learning a more interest-based approach. And the other critical learning I think exists for lawyers is learning how to be part of a professional team. And quite often I hear lawyers say, oh, well, I'm collaborative, in terms of the way they approach practice, and most of them are. But working in a team together with a family requires quite a new skill set. And it requires lawyers really learning when to lead, when to step back and let others do the leading, including the clients. And I think as a trainer, the thing I've found lawyers struggle with the most is that interest piece, is really doing a deep dive into what is truly important for my client. What is important to them about the way in which we step through this process or step through a resolution process? What's important to them about the ongoing relationships that are at play here? What's really important to them substantively? Is financial autonomy and confidence important to them? Is having the children grow up in the same community important to them? And if so, why? And just digging really deeply to understand their motivations. So it's not a superficial exploration. And I find lawyers particularly, it takes some time and some really concentrated effort to be changing that aspect of their work. But what collaborative practice, offers is a wonderful process to then use that information. But I argue that really good understanding of what your client's interests are, I draw it up in a compass for them, can guide you through whatever process you use, whether it's litigation, lawyers' letters, mediation, or collaborative process.
Cool. So you've mentioned the participation agreement, where parties agree not to go to court while the process is underway. Why is it so important that lawyers not go on and represent those same parties in any ensuing litigation? Why do you think that's a crucial part of that agreement? Because I guess we haven't touched on that. It's the American model. Is it also the New Zealand model that if you have a lawyer and then it doesn't work and you end up having to go to court, you can't use the same lawyer?
Yeah, it is pretty much internationally the standard that there is this what we call the disqualification clause. It's what I see as one of the key anchors of the collaborative process and what makes it quite different. So it is a central tenet of the process, and it's in that participation agreement, as you mentioned, Tina. So the lawyers are essentially saying that if this doesn't resolve itself in collaborative process and it needs to go to a litigation type process, whether that's arbitration or litigation, then the lawyers will step back and new lawyers will pick up acting for the parties from there. Now, the reason it's really critical is if you imagine for one moment, Shelley and Tina, that you were having a conflict or a dispute that you came to the collaborative process with, and I was acting as Tina's collaborative lawyer, and we're saying, oh, everyone be really open and transparent, and you're signing to say you'll be that way. I'm picking Shelley. You probably won't be feeling too comfortable about being open and transparent if you're thinking Selina could be eyeballing me across a courtroom ultimately and asking me questions about this. Yeah.
The same thing happens in mediation though, doesn't it? And parties cover that by agreeing on confidentiality. Like, you can't take things that are said in the mediation through and, use them against the other party.
There's a lot of stuff that happens in mediation, though, that actually informs how the role you may take then when you are litigating a case. If you mediate and you then go on to have to go to court and represent your client in court. There's all sorts of things you have picked up about the other party from that mediation experience without actually having to delve into what was said and done in the mediation. You've picked up, how they react under questioning. You've picked up what some triggers might be for them. You've picked up all sorts of things around the way they may conduct themselves as a witness.
Lawyers aren't like that. You're making us sound like sneaky and devious.
Again,
but
and that's
in all
when you have
honesty,
a process that's not devoid of a parallel litigation strategy. In mediation, often you're coming to mediation right before you're about to go through those courtroom doors. I've mediated a number of cases where that's been the case. And look, I collaborative practice stands on the shoulders of mediation, and I am a great proponent of it. But I do think that sometimes it's artificial to say that confidentiality aspect of the agreement prevents things being knowledge that we've gleaned is being used in litigation.
So what does that commitment, so binding them to that, what does it add to the general, and does it take something away? And I'm thinking of that ability to send something up to the video referee. There are things like a Section 15 adjustment, which are hotly, they're tricky areas that people often come to a dispute. They're not aware of them. It's an anathema to the way that they thought things worked. What do you mean? It's not 50-50 sharing. And there are other tricky issues where one party can become quite intractable, and sometimes it's useful to be able to throw something up to the judge and say, please make a decision on this point, because otherwise somebody's just going to have to give in.
I'm avoiding saying something about that, which is, I'm going to say it anyway.
Yeah, say it, go.
Some might say that that's lazy decision making and lazy problem solving. But having said that, I've been in enough collaborative cases and mediations and court cases to know that to know some of what you're speaking of here and the problems that we face, and trying to find cost-effective and time-effective solutions is really important. What in terms of some of those really tricky points, we often use our neutral experts. So, say for example, if a couple are considering a problem that might look like this, the problem they're considering is, how can we avoid a situation where the children are moving from one home, which is akin to the prince's palace, to another home with the other parent, which is akin to a pauper's home? That sort of, which is really an interest-based redefining of Section 15 and spousal maintenance. If that's the problem they're looking at, one thing I'm doing at the moment in a collaborative case I've got is the lawyer and I are sitting down together and we're saying, okay, what can we agree on this from a legal analysis, and what can we agree an award might look like on this? And we've pulled out Arnold J's lovely formula, and we're crunching some numbers, and with the help of the financial neutral, we're able to do that. I'm aware of other cases where the parties have jointly engaged a financial to come on and actually do that calculation for them, and to say, yes, this is what the number or the range is looking like. I've been having discussions with some colleagues in Australia at the moment about those stuck moments, and whether or not there is that scope to go, okay, we're stuck on this issue. We've got one issue that's a roadblock, and maybe taking that to arbitration or litigation and seeing if that's a possibility. Of course, that flies completely in the face of what we're agreeing to in the collaborative process of not going to court.
But you can see where that would really work, especially like an arbitration, right? So family law arbitration, you choose your judge effectively, you both agree on it, and then what you're saying is we're like two kids scrapping in the playground. By binding ourselves to this process, we've effectively agreed not to go to the teacher, right? But sometimes to really balance things up, you got to go to the teacher. And I guess that's where I feel like, is that a plug-in that is missing in collaborative law that we could, or is it something that you use?
I haven't, in my experience, found it to be necessary. I've just found that the parties value the principles and the and the process and what it is intending to do. And there's a reason they're in that process. They don't want to go to court. A number of my clients have done that with previous separations. They don't want to ride that rodeo again, and that's why they're drawn to this process. And so I think there is enough other ways we can try and enough other ways to problem solve and be creative around that avoid us having to do this. And again, I think a really key one is that perhaps having an early expert determination, having a financial neutral come in and do some numbers for us. Yeah.
Cool. Okay, thank you.
Far more cost effective than litigation. Yeah.
Yeah, because I'm thinking of the situation where you've got one partner that considers that they supported the other partner through the course of their relationship, and then it's the ultimate a sting in the tail that then that partner that they've supported all their life then suggests that they get a bigger share of the asset. That is just absolutely blows someone's mind. And how can that opinion be changed? Really, that's just like a complete attitude. That how do you change that?
Yeah, and there's a whole lot of, we see this every day in our work, and some of the attitudinal issues can be around viewing my income as my income. You chose to stay at home, you chose to go and have ladies' lunches and not work when you could have gone to work, all those sorts of things, which we know the courts take a very different perspective on.
Exactly.
I guess there's two ways that we approach this in collaborative process. The first way is in our screening and our assessment. It may be that if you've got a client who's steadfastly we have some nice questions that we can ask in that assessment, and if you've got a client who's steadfastly holding on to that, I'd be asking them some really curious questions about what's underlying that, and but it may be that process is just not for them. Equally though, it is a process which does allow people to, even if they aren't recognising the other person's contribution to the relationship or to the family, that they can recognise interests that they have pertaining to their children, and recognising that for their children's well-being, financially, the other parent needs to be doing okay, to be doing well.
It's quite a big ask. Like when I think of my own personal mediation, that was definitely the view that that my ex took, was that exact scenario, and it took the mediator really to say that's not the position. You know what I mean? That this is what the actual law says.
I guess I've got a few, like I've got a bunch actually of clients who were the main breadwinner, who are they are ready to acknowledge that, I get that concept that our roles in the family have left us with a different earning capacity now, and that's going to have an impact on not only my ex but my children, right? And there are lots of good people who are trying to work through those and make a fair adjustment. And on the other side, there are some people who were at home who have, I'm not sure whether it's, who have pretty high expectations about what they're going to get. And I guess I'm just reading between the lines. The people who come to collaborative law, they're generally family lawyers who are really experienced in relationship property law and family law. So rather than having a lawyer who does a bit of everything who happens to be handling a relationship property matter, you've got other lawyers who are going to be saying, well, their lawyer's right, there is, it's not 50-50 in these circumstances. So I guess maybe do you sort of work together to help them see what a court, because that's really helpful, because oftentimes you can be saying to the other side and they say, no, it's 80-20, and you're like, come on,
really?
It's not.
And that's what I was about to say, when I was hearing your story, Shelley, from your mediation, is sometimes the most valuable role we have as professionals is creating doubt. Sometimes people come very resolute with what they think is happening, or very resolute because, the Lululemon lawyers, the other parents outside the school gates in their activewear telling them, oh, you should get this and you should get that. They come very resolute. And so our role is sometimes to say, to question that. And it can be your own lawyer saying, actually, you just heard what my colleague here has said, and I have to agree with them. That does create doubt for them, and they start to go, oh, yeah, I'm less certain. Maybe we do need to look at things again. Yeah.
Yeah, it's not an uncommon thing to have a client come to you and say, oh, I hope my ex gets a terrible lawyer, and not as good a lawyer as you. And we always say, no, you hope that your lawyer gets your ex gets a damn good lawyer, because they will be telling them the same things I'm telling you, and that's how we jump to an outcome.
And that's one of the beauties of collaborative processes. You get to have very trusting and great functioning relationships with your colleagues. And so you come into these meetings and it's really amazing teamwork that takes place. And as I said, I've got a colleague and I at the moment who are just going to sit down and we're going to say, okay, well, what can we as a unified front tell the parties? Oh, I've lost you there. Oops, you're back.
Okay, next question. Does choosing one expert, like an accountant, take something away from the process, e.g., well, for example, by removing the possibilities that can be explored when you have two experts, two accountants, dueling over differing opinions?
Yeah, I mean, obviously, the more brains in the mix, I think the more potential you have for options coming. But I guess my answer probably rests in that word dueling. I'm not sure how beneficial that ultimately is. Certainly, having the one say, for example, having the one financial neutral helps contain costs. And I just find that neutral is so important to the functioning of the process, because they're able to build such trusted and positive relationships with both parties. And when we're thinking about the financial neutral, that role is just so much more expansive than we view it through a litigation lens. So, think beyond forensic work or share valuations or Section 15 calculations. In collaborative process, the financial plays a really important educative role. So that helps to ensure that the party, and there is usually one who has lesser proficiency or lesser confidence around the numbers, understands those and feels really confident with them, which makes for far easier work when it comes to getting agreements in place. And usually,
so then do you argue about the input, not argue, sorry, do the lawyers then contribute by being able to discuss the merits of the various inputs?
Yes.
Into, for example,
absolutely.
like a Section 15. Yeah. Okay.
Yeah.
And so is that financial expert also educated in collaborative practice?
Yes.
Or is it?
Yeah.
Okay. So
All
they've
of the
gone through
professionals are
similar
trained.
training.
Yeah.
Okay.
All of the professionals are trained and they train together generally, which is great because it starts to help forge those important relationships and working relationships together. And the other thing, sorry, I was going to say that the financial also does is they really help nut through some of those interim financial issues and the budgets and things like that. And without dwelling too much on war stories, I'll just never forget one of my earliest collaborative cases with a really great collaborative lawyer in Auckland, Karen Monet, and her and I spending a meeting with both parties getting agreement on the budget. And at the end, we just said, never again, having one financial is just the way to go on those things. So we find that just as really efficient and cost effective, using that one professional to be able to go through the bank statements, go through and do the analysis and help the parties come to agreement about their interim finances and their budgets. Yeah.
Great. Okay. How do you respond to concerns that having, this is a quote from an article I found, a system that focuses on emotions and relationship preservation, almost to the exclusion of substantive concerns, is likely to do little to alleviate the post-divorce suffering of women and dependent children? That's a
I think I know the article you're referring to, and I think I know the research that comes out from.
Right, yeah. It's just, it talks about that, we were talking about earlier, a cognitive bias called bounded rationality, which I had never heard about before, but which talks about how bad humans are at predicting the likelihood of outcomes. So we might, how does this system ensure that we're not our own worst enemies in what we agree to?
Yeah. And I think in any process, whether it's mediation or litigation or collaborative, all the professionals need to be really mindful of the power imbalances and the biases that are at play, because irrespective of the process, that will be happening. We're all human. And so in collaborative process, our professionals in New Zealand, one of the things we're trained to do is understand people's conflict styles and help our clients identify these, which is really, really helpful if you start to see one party capitulating. So really understanding your client's conflict style, the other party's conflict style, how they respond when they're in conflict, and what's and the background, how they've resolved things in the past or not resolved things at the past. What's their usual template when they're in these situations? Understanding that just really helps attune you to what's happening in the room as well, and helps you name if you see people falling into those traps, shall we say, or those previous templates. The professional team also debriefs and has preparatory discussions. And these are usually very frank and very constructive. We name what we're seeing in the room, and the dynamic between the parties. And then we're working to really proactively find ways to mitigate that from happening.
Okay. So you can have some of those robust conversations without upping the aggro in the room.
Completely, because at the end of the day, we're all there for the same purpose, to try and help this family reach agreement and do so in a way that's constructive. And so when you focus in on that as your common purpose, it means you can have these discussions which are quite robust. And remembering as well, the parties have their own lawyer there, and we're there to be their advocates, to be their voice, to notice behaviours and to name them and address them in a constructive manner, and also to be coaching our clients, and asking them questions and coaching them around approaches they can take that may be more conducive to reaching agreement and overcoming some of those unhelpful behaviours.
So I can't help but think that could be a useful process to take maybe 5 years earlier. Because half the time the reason I think that would be actually a really useful exercise.
And some of the research speaks to that. Some of the research says, parties speak to coming out actually feeling in a better place in their communication with for the future. And that's one of the great opportunities. It doesn't happen for everyone, but one of the great opportunities the process offers is that chance to redefine how you relate to one another when problems arise.
So do you meet separately with your client? Because I know some practitioners don't do that. They only meet in the room, but you talk with the other lawyers and then you meet separately with your client.
You always will. I haven't come across lawyers who would never meet with their client individually. You always meet with your client individually,
and some of the articles.
You're meeting with them individually at the outset and really scoping what's important to them and what process is going to be appropriate and priming them for that process. And then throughout the process, you're meeting with them. You're doing debriefs with your client individually after every meeting.
Right.
And I've just, this week been busy meeting with some clients who are in the collaborative process to really set them up for option generation and considering options that are on the table and helping them start to focus in on what the possibilities may be. Yeah.
Are you on one side in that one, or are you?
When I'm in a collaborative process, I'm acting for one party.
Yeah. Okay. So I'm going to combine these two next questions, but so this is sort of back to the you can't use the same lawyer, which I know is a linchpin of it. So a lawyer can recommend or that a party walks away in a mediation or if it isn't working for them. But in collaborative law, the cost of that, and I know there's an ongoing cost if you go to court, but the cost of that is quite massive because you've got to instruct a new lawyer and bring them up to speed. And I'm just interested in, do you think it's worth it despite that?
Yeah,
to have that as an underpinning principle.
I think as you devote time and energy and money to any process, you naturally develop a bias, an escalating commitment to that process, no matter the case or the
Mm,
process at hand. Um, it's a really good question. I don't think that the costs of having to engage a new lawyer would change my support of the disqualification clause. I just
mm,
think that the openness and the transparency that helps engender in the process outweighs, the possible costs of then moving to a new lawyer and having to litigate
mm.
things. In that, it helps get agreement to avoid having to go to a new lawyer and litigate
Yeah,
things.
well, exactly, I guess. Yeah, it
Yeah,
creates some pressure there. Okay, no,
yeah,
you've
and
answered
and
that
it,
one.
and the other thing is, well, I mean, it's very few cases that end up leaving the process and having to go to court. Sometimes, if they leave the process, they will still work within other non litigious processes, other consensual processes to reach agreement. Or if they did have to go to court, they will have narrowed the issues right down and have collated a lot of information that is then useful for court. So, yeah, I
Mm.
think
So
it's
these
still
aren't
merited.
without prejudice negotiations.
No,
You
they
can
are.
they are okay. So when you
Yeah.
go to court, then you couldn't really hold the party to those things that they've agreed.
You can't, no, you can't do that, and you can't just, it just as in mediation, you can't say he
Mm,
said this, she said that
mm,
in the collaborative process. But one of the things you often have done is you may well have said, well, actually, the only two issues we need to go to court on are these two. The rest we're
hmm.
fine with. Or,
Right,
and
as long as they
and you
stick
may
to
well have
that. Yeah.
said, yeah, we're happy with this valuation information. We're agreed that that valuation information can be used. So you're not having to reinvent the wheel entirely. You're not having to start at the beginning.
What creative ways can you use the process? Can you give us an example of where that worked well?
Yeah. Look, one of the beauties of the process is it's really adaptable.
Mm.
Years ago, if you went to a collaborative conference, you would hear a lot about the gold standard and this is the way the process should be done. And that it was a little problematic for me because here in New Zealand, we have different cultural context and also we have different resources available to us. What I was really thrilled to see at my first in-person conference after the pandemic was a shift in that and people starting to be delivering papers on the adaptability of the process and adapting it to meet cultural need, adapting it to meet financial need, doing a really streamlined process.
Mhm.
So there's all sorts of amazing things that we can now build on and adapt the process for. As I said earlier, there's some really exciting things happening in Australia with the use of child development specialists. Um, and it's a very creative process and it can be used in a whole range of different disputes as well.
Mm,
There are other lawyers using it for trust and estate disputes or issues around closely held companies and shareholder disputes, employment law and other aspects of civil law, particularly in the US, it's being used for. So
mm.
lots of different applications that it can be used for.
Yeah, cool. Okay, if an agreement is reached, what then? And what if an agreement can't be reached? Because there's
Yeah.
a next process, isn't there?
Yeah. So if you're talking about a property or a parenting dispute, then the agreements are formalized in exactly the same way as they are in any other process where agreements reached. We'll
Hmm.
have a relationship property agreement. Both parties have to have had their independent advice and have it certified. We can seek consent orders from the court because it's it's a non-contested application. So we can seek consent orders if they're needed to give effect to the relationship property agreement or to get consent parenting orders.
Mm,
Um, yeah, and so when agreements reach, we'll often come together for a final meeting and everyone signs the agreements together. And it's nice to give the parties, an opportunity to reflect on their experience and to make any remarks they may wish to in order to close the process. And those can be really quite poignant meetings. But equally, if agreement wasn't reached, and I'm only really speculating here as to what I'd be doing because I've been fortunate to be involved in processes where agreement is reached. I think it's just equally as important to give the parties those opportunities to reflect on the experience, say whatever they need to say to try and close the process, but also to give them affirmation as to the gains they did make, because there'll always be some gains made when you're bringing people together and having these discussions, even if it's just developing a deeper understanding of each other's perspectives, and to step through with them what the next steps will be. There is a 30-day cooling off period. So you might say, and I've had a case recently where this has happened, where one party says, I'm terminating it, I'm walking away. There's a 30-day cooling off, which means no proceedings can be embarked upon unless there's a really urgent safety issue within 30 days. And that just allows a chance for cooler heads to come to the fore. And as it happens, that process is probably back on track again.
Okay. Yeah, just something you mentioned there when you're talking about you can get a consent order and to resolve something. Can you have started proceedings and then decide we're going to step away and see if we can go to collaborative law? So could you have them sort of running in the background in that situation?
Really good question. There is, I haven't seen it done here in New Zealand, but there's no reason why it can't be. I know in the US and other parts of the world that certainly happens. And in fact, courts and different legislatures have recognised collaborative process and adapted legislation or procedure to enable that to happen. I guess my only comment with that is that it's probably a bit harder. The work's harder because by firing off proceedings, you've instantly sort of positionalized people. They've had advice that's very rights-based and very entitlements-based. And so you're then sort of trying to bridge probably a wider gap between them. Yeah, but
it's not the ideal.
It's not the ideal, but I know it is happening overseas. Yeah.
Okay, cool. Do you want to do the last one?
Sure. Has the Ministry of Justice done a review of how the collaborative practice is working in New Zealand?
No, I mean, I think we're relatively still in our infancy. We're sort of at the toddler stage at this point. Even though it's been around a while, it's been a slow burn. It's kind of problematic because on the one hand, you kind of want to have a reasonable number of participants engaged in the process to get reasonable data, reasonable sample size of data to make any research or any and review meaningful. And so it becomes a bit circular, a bit chicken and egg. Sometimes you're not going to get more practitioners or people operating in this space without that data. I have to say, it'd make a great PhD topic or master's thesis if anyone was wanting to look for a topic.
Yeah, cool. Awesome.
Yeah. But it is happening regularly and it's happening successfully for the most part. Doesn't mean that it's all, for the parties are not experiencing fairy dust and unicorns the whole way through. It's tough coming to any process with the really raw emotion and conflict that often is carried with a family that is going through a separation. And, we all have to be attuned to trauma informed work when we're working with clients, just as we do in any other model. But I have to say it gives us all a way to work that's really aligned with values of cooperation, teamwork, and serving clients in a holistic way. And as I said earlier, it makes for a great day at the office. Yeah.
Yeah. Cool. And if somebody wanted to get into it, where could a lawyer or another professional train? How can we sign up?
There's trainings that happen all around the world, and so the IACP calendar is a really great start on their website. But here in New Zealand, if you're wanting to do a training here, then we've got one coming up. I'm just firming up the dates for that. It's likely to be July or August. And so you can just contact me directly or contact Collaborative Resolution New Zealand. Yeah.
Cool. Awesome. So now we come to the quick fire questions, which, so you've got...
meant to be 10 seconds.
Yes.
Often it takes more than 10 seconds to read the question.
Yeah. So 10 questions, 10 seconds each to answer them. Let's kick off with, how many collaborative law practitioners are there in New Zealand?
Oh, good question. I think I've lost count because Collaborative Resolution holds most of that data. I'd say my best guess would be about 100 to 120. Yeah.
Okay. If you hadn't been a lawyer, what would you have been?
Probably a teacher.
Okay. What is the difference between an officially collaborative lawyer and a lawyer who collaborates?
And officially, collaborative law is one who's undertaken the training and the skills work that's needed to practice in this process. Yeah.
Okay.
What is the best bit about collaborative? I always pause because my question says collaborative law, and I have to.
I appreciate that.
What is the best bit about collaborative practice?
The best bit, for me, it's seeing clients come up with really tailored, bespoke solutions that suit them and their family. They might not suit the next family that comes along, but they suit their family. And those are often solutions that are very different to what they may get if they went down a more traditional negotiation route.
What's the quickest collaborative practice outcome you've been involved in?
I had one done in 2 meetings. That was quite unique. We had some time pressures because of parties. One party lived overseas and was travelling in and out of the country. But Karen Monet and I managed to, get them
Knock it off
resolved in two meetings. Yeah.
Cool.
Okay, so how many meetings do the parties normally get? And is there a point at which you just call it and say, enough is enough?
Yeah, everyone's hung up quite a lot on the number of meetings that it might take. Again, I come back to, and I understand that because we want efficiency, we want things to be effective, and we want to keep costs in check. But the number of meetings really does depend on the parties. As I said, I had one couple who've sorted it out in 2 meetings, another one in 3, but they're quite different and in a very different space to perhaps the couple who needed 4, 5, or 6 meetings. Some will be resolved in a couple of months, others will take much longer because there are other things in their lives that are happening for them that they say, I just need to press pause on this. And sometimes, I say to clients, pausing is sometimes progress if it means either or both of you are able to then come to a meeting and participate really effectively. Yeah.
Next one. What does the process cost?
Well, again, that's how long's a piece of string. It really does depend on the parties, the complexity of their matter. Are we talking about just working out how to divide up the home and a mortgage and some KiwiSaver, or are we talking about complex trusts and
So
company
you each
structures?
pay your lawyer. That's where the cost comes from.
The cost comes from
and the expert.
the professional fees. But one of the lovely points of difference is often at the first meeting, the first question that the parties are considering and resolving is how are they going to meet the costs? It's not necessarily going to be that each is left having to carry the can of their own lawyer's costs, that they may have a common kitty or find other ways in which they're going to do that. Yeah.
I sort of asked this before, but do you train accountants in particular as collaborative practitioners, or do they get confused by having to deal with people? Little lawyer accountant joke there.
Poor accountants.
We love accountants.
Yes, they do. As I said earlier, they do train alongside us as lawyers, and I have to say I really value their input. And often, because they're neutral, they are just a critical piece in the process working successfully. Yeah.
Cool. Is there a professional body that deals with complaints? And if not, does the Law Society get collaborative law?
No, we don't. We tend CRANS isn't a place to go to with a complaint as such. Yes, we all have the guidelines and standards and ethics that we have to abide by, which accord with the IACP guidelines and standards and ethics. But at the end of the day, each professional has their own regulatory body to which complaints should be made. Yeah. So in my case, it would be the Law Society. Whether the Law Society understands collaborative practice, that's something I probably can't comment on. I think, like everyone, they're probably getting to grips with this, and as it gains more and more momentum,
Who do you think shouldn't engage a collaborative law process?
Shouldn't engage in a process?
Yeah.
I think anyone where it's going to be unsafe. And that's physically or psychologically in all realms. If it's really going to be unsafe, and my radars, I've done years of family violence work, my radar is pretty quick to start pinging in my head if that's likely to be happening.
Cool. All right, you'll forgive this question. Stuart Webb created the rules around collaborative law because traditional law and court had left him burnt out. Is there an argument to say collaborative law actually benefits lawyers more than their clients?
I think it doesn't benefit them necessarily more. I think it benefits both in different ways. Yeah.
Okay.
But certainly lawyers speak to having high levels of professional satisfaction and fulfillment from this work. Yeah.
Cool.
There are a lot of studies that show that women do worse in mediations. How does collaborative law improve those statistics? If it does it?
It's interesting. The research that I've reviewed shows, in fact, there was some research out of Canada of lawyers who essentially were saying they felt that their clients were getting really good just outcomes out of collaborative. And when you looked at the response rate for lawyers who were doing litigation and arbitration, it was really low. So that was a really interesting to me, that, you know, the lawyers themselves were identifying this difference. Yeah.
Yeah, I guess it was mediations. I was
Yeah.
thinking with those differences. But yeah, no, that's a good answer. All right, last question. What links these statements? And sing out as soon as you know the answer, or think you know the answer.
Gee, no pressure.
Yeah. Don't blame me. You need to calm down. Look what you made me do. I bet you think about me. I forgot that you existed.
Oh
I
my
knew
goodness.
you would. You'll get it soon. I knew you were trouble. Is it over now? We are never, ever getting back together.
Oh my goodness, it sounds like a topic.
You haven't got a
statements not to be said at collaborative process.
You obviously don't have a teenage
Girl.
daughter.
No.
Yeah.
I don't.
Sorry to
Please
gender
do tell
her,
me
but
what it was.
those are all the titles of songs by the lovely Taylor Swift. And there are so many more appropriate ones that I had
My
to narrow
son is
down.
so not a Swiftie, so
Ah,
he'll be quite
okay.
proud I
We
didn't
try
get
to
that.
we try to work one Taylor Swift reference into every episode. Okay, well, yeah, thank you so much, Selina. That has been
Thank you.
not a whistle stop tour. It's been a good in-depth discussion about collaborative practice and an exploration of what makes it so good, and a good challenge to what we litigators think about how collaborative we are. Could we be more collaborative? Could we be collaborative lawyers with a capital C and a capital L? Anyway, this has been Divorce Cafe. Thank you very much for listening. I hope you enjoyed it. You can always send us your questions to divorcecafe@hendersonreeves.co.nz. She's Shelley Fidel. I'm Tyna Henderson, and join us next time. Thank you, Selina, at
Thank
Lighthouse
you.
Legal.
Yes.
Is that where, where you
Yep,
belong now?
Lighthouse Legal.
Awesome. And in sunny Christchurch.
Christchurch, Auckland, and Queenstown.
Okay,
All the
nice.
bright spots covered.
Perfect. All right. So good to talk to you.